Well, good morning. Welcome to the Mid-Speeds live class. We'll go ahead and get started with some consonant compounds. Here we go. Ready? Less, gave, sail, regret, card, rest, ready, cut, delay, looking, replying, surely, orders, ordered, war, half, Friday, between, things, offer, recent, weeks, invoice, promptly, supply, country, indeed, connection, different, where, records, trouble, contract, talk, taking, accept, sincerely, December. All right, now let's do a basic brief review from theory. You're going to hear knowledge, acknowledge, why, yes, purchase, been. Here are your sentences. I thought I was only purchasing what I needed, but I acknowledge that I made too many purchases. When a judge takes cognizance of a fact, he is acknowledging that the fact is true so that the parties do not have to prove it. Put your purchases in the trunk of the car. Cognizance is a judge's acknowledgement of the facts. Are you purchasing your home? He has acknowledged the seriousness of it. Yes, I am ready to go. He is knowledgeable in the field. Why has he been there so many times? I have been studying to enhance my knowledge of that subject. I acknowledge receipt of payment. How many purchases did you make? You should acknowledge that debt. Why, you purchased it over a year ago. Why is it said that a little knowledge is not a good thing? Yes, I would like to purchase that coat. Why didn't you acknowledge my presence? Knowledge is the state of being aware of something. It has been a while since I have seen him. Why has it taken so long? Why has it been so long? Why is it you have been there every day? All right, let's do some consonant compounds. Here we go. Frown, gray, float, thus, fright, grin, blow, quit, shake, bright, quiz, sneer, brown, stall, twins, score, flax, twine, flit, drought, scab, bliss, fry, gloss, star, clot, slim, snake, click, glue, swell, sweat, dream, share, twist. All right, moving into a numbers drill. We've got items with numbers. Here we go. Rye, 6,961. Artichokes, 4,872. Alfalfa, 8,525. Barley, 6,354. Corn, 5,300. Sugar beets, 2,884. Grapefruit, 9,291. Vegetables, 1,552. Flax, 2,323. Milk, 1,098. Butter, 1,236. Cotton, 4,830. Grapes, 1,890. Wheat, 8,525. Potatoes, 5,720. Lettuce, 1,000 $777. Onions, $7,226. Tangerines, $8,363. All right. We're going to do some diphthongs. This focuses on oi, ah, and ow. Here we go. Bout, toy, shout, route, noise, sound, cowl, draw, owl, house, crawl, boy, toil, flaw, loyal, found, drawn, dawn, foil, saw, spoil, spout, out, calm, void, power, shout, howl, palm, oil, trout. And here are your sentences. We caught trout on our trip. It reminded me of the time we went deep sea fishing for flounder. Roy gave a shout of joy when he caught it. My mom has a recipe for boiled flounder. Take a shower now before you go to the pool and take your own towel. You will enjoy swimming even though the pool is loud and noisy. That soil would be good for growing soybeans. You will need to boil and toil to get a good crop. Use that coil. We took a trip to the Leaning Tower of Pisa. When we got up at dawn, there was no sound. He threw a switch to turn on the power as the river cascaded over the dam. Crawl under the table to get your toy wagon. There is a flaw in the paint job. Keep the fish on ice or it will spoil. He had a bout of flu last winter. Are you good at draw poker? The spout is clogged. Void that check and write another one. Okay. Now, I've got some sentences that focus on final consonants PT, PTS, PL, PZ, and PLZ. Here we go. He had a rapt expression. I will not disrupt your stops. He swaps this for that. We had crepes for lunch. The flaps were kept dry. Throw the scraps off the steeple. She weeps as she sweeps. Corrupt cops are rare. And you can squeeze corrupt, K-R-U-P-T. We made an abrupt stop. The tops of the steps were replaced. Triple the amount of the gift. Staples enhance a diet. It was a new concept in drapes. She drops everything. They removed their tops to swim. Can you adapt to the change? Small drips and large drops are common. He kept the maple syrup. She types while on trips. I will attempt to adopt you. All right. Now, I've got a paragraph here that focuses on the following phrases. We have when he is not, if he had not, in and out, which is N-O-U-T, of the, would have, did you, he is, could be, before the, will the. All right, and here is your paragraph. I'm going to read this at 1:20. We have had several verbal confrontations with Joe Martinez over the use of the equipment. When he is not around, things run very smoothly. We would have had no problems if he had not insisted on everyone signing in and out. Did you know he is requiring this of each employee? I had hoped our differences could be resolved before the department meeting next Wednesday. Will the other employees be willing to discuss this problem at our next meeting? Okay, so let's do that again at 1:40. Here we go. We have had several verbal confrontations with Joe Martinez over the use of the equipment. When he is not around, things run very smoothly. We would have had no problems if he had not insisted on everyone signing in and out. Did you know he is requiring this of each employee? I had hoped our differences could be resolved before the department meeting next Wednesday. Will the other employees be willing to discuss this problem at our next meeting? All right, so let's do it one more time at 1:60. We have had several verbal confrontations with Joe Martinez over the use of the equipment. When he is not around, things run very smoothly. We would have had no problems if he had not insisted on everyone signing in and out. Did you know he is requiring this of each employee? I had hoped our differences could be resolved before the department meeting next Wednesday. Will the other employees be willing to discuss this problem at our next meeting? All right. Now, I've got a most frequently used word drill. So these are words that are often heard, and it's in the following paragraph. Here we go. You're going to hear interested, didn't, meeting, show, probably, used, meet, either, probably, used, subject, price, end, bank, end, coming, request, position, addressed, address, question, afternoon, general, reference. And here's your paragraph. Yesterday afternoon, I attended a general meeting at the bank in reference to the increased price of housing. We are interested in how we can make or meet the needs of buyers, either by offering lower interest rates or variable interest rates. The subject was discussed at length, and we ended up coming to the conclusion that by the end of this year, we would probably be in a better position to address the problem. My question now is how we can request more interbank assistance. We used to have more cooperation among the banks. We didn't have all these funding problems. Today, it is difficult to show a profit and to continue the home loan plan and to service our customers' needs. Okay, so let's do that one more time at 1:40. Yesterday afternoon, I attended a general meeting at the bank in reference to the increased pricing of housing. We are interested in how we can meet the needs of buyers, either by offering lower interest rates or variable interest rates. The subject was discussed at length, and we ended up coming to the conclusion that by the end of this year, we would probably be in a better position to address the problem. My question now is how we can request more interbank assistance. We used to have more cooperation among the banks. We didn't have all these funding problems. Today, it is difficult to show a profit and to continue the home loan plan and to service our customers' needs. All right, so our last, actually I've got Just a couple more drills before we move into literary. I've got a number drill that's in the form of a paragraph, and because it's numbers, I'm just going to read it once at 120, and it's identification numbers, okay, with different credit cards. All right, here we go. When my wallet was stolen, I reported it to the credit card hotline that the following cards were stolen. American Express card number 4989800002, MasterCard number 876310-90, Intercity Bank card number 509-304-1054, JC Penney card number 543-978982, Visa card number 5473-78-1492, and mobile card number 532-486-7478. Is this information in your report? Okay, just date that so we know that we covered it. All right, I've got some Tangle Tamers. Here we go. Ready? Health coverage, degrees Fahrenheit, cryonic suspension, merciless massacre, exhausted refugees, transition of power, crooned comfortably, strategic installations, cryoprotective chemicals, computer specials, requirement challenged, commuter special, mathematician succumbs, accounting controller, nuclear circuit breakers, medfly reproduction, allegedly committed, malathion spraying, studio environment. All right, our last drill is going to be names and addresses. Here we go. Ready? Audrey H. Hextall, Hexdall, CPS, 425 Ingleside Avenue, Aurora, Illinois, 60506. Nancy T. Perino, Perrino, 5207 Pierce Road, Warren, Ohio, 44581. Lisa G. Postie, Postie, Lincoln High School, 1320 South Olympus Drive, Naperville, Illinois, 60565. Ronald L. Bolam, BOLAM, Alternative Education Program, Park Avenue School, 5171 Park Avenue, room 404, Bethel Park, Pennsylvania, 15102. Sylvia W. McTagg, MCTAGUE, West Texas State University, Counseling and Testing Center. P.O. Box 1401, West Station, Canyon, Texas 79016. Kenneth G. Steinberg, Steinberg, Robert McQueen High School, 6050 Lancer Street, Reno, Nevada 89503. Patty L. Johnson, Johnson, Route 1, Box 167, Gravity, Iowa 50848. Jean A. Thompson, Thompson, Route 10, Box 66, Bresford, South Dakota 57014. Tarpon Springs High School, 141 Gulf Road, Tarpon Springs, Florida 33589. Attention, Mary Helen Albrecht. All right. Now I've got some literary and jury charge for you. We'll go ahead and start with literary today. We're finishing up our educational benefits from Life Aboard the Navy Submarine Force. So we're going to finish up educational benefits today along with eligibility. All right, here we go. American Council of Education, known as ACE, organization recommends colleges award up to 77 credits to sailors completing Nuclear Field A School, Nuclear Power School, and prototype training. Must petition a college to receive the credits, only a few classes short of an associate's degree. Advanced technical training. Nuclear field training pipeline is up to 22 months long. Emphasis, understanding, and application of computer technical concepts. Operational experience. Program for afloat college education. PACE. Fully funded undergraduate college courses offered aboard the Navy ships. Service Members Opportunities College, known as SOCNAV. Navy Job Experience and Completed Schools, college credit. Independent study courses for college credit. Free tests for college credit. Full transfer of college credit between a network of 63 colleges worldwide. Tuition assistance, TA. Tuition payment for any accredited college, vocational, technical, or business school courses taken in your off-duty time. Established degree paths for NF sailors. Colleges, universities credit Navy training toward a degree and only require a limited number of courses to be completed to receive a degree. Some of the institutions that currently have associate and bachelor degree programs established with the nuclear power program include Old Dominion University, Rogers State University, Thomas Edison State College, and University of Phoenix. For details of current degree programs, visit www.navycollege.navy.mil. Eligibility. The nuclear power program allows those who qualify to gain a solid understanding of science and technology, as well as the ability and competence to operate advanced nuclear propulsion plants around the world. Candidates should pursue higher level math and science courses. Any substandard academic performance in high school may affect your eligibility. Only the most qualified candidates are selected. Basic qualifications for the Navy nuclear power program include the following: U.S. citizenship and no dual citizenship, high school diploma or college degree, successful completion of 1 year of high school or college algebra, good academic performance in school, qualifying scores on armed services vocational aptitude battery test known as ASVAB, and an advanced placement test if necessary. No older than 27 years on the date of enlistment. Meet physical standards. Sound moral character. Call Navy.com nuclear, contact Navy.com nuclear, or call 1-800-USA-NAVY. All right. Now, I'm going to pick up where we left off with Bodie State Historic Park. We've been working on that. All right, here we go. Ready? U.S. Hotel and Occidental Hotel Suites and Sites. On the east side of Main Street stood the U.S. Hotel to the north and the Occidental Hotel to the south. Ruins of a stone warehouse and the Occidental stable across the creek are all that remain. Only a stone sidewalk marks the site of the U.S. Hotel. Imagine how this corner looked when Main Street was a solid mile of 1- and 2-story frame buildings. People who walked this busy street came from all over the world. Records show residents from Italy, Ireland, England, Mexico, France, Germany, Canada, and elsewhere. In 1880, 16 African Americans appeared on the census. Their occupations included hairdresser, barber, waiter, cook, laundry worker, and miners. In April 1880, the death of one of Bodie's most well-known African Americans was reported in the Daily Bodie Standard newspaper. William O'Hara, known as Uncle Billy to many, had come to Bodie in 1863. For many years, he ran the boarding house of the Empire Mining Company. It was reported that he acquired the property of what would later be known as the Standard Mine because of a debt owed him. He tried to sell it, but mining experts told him the property was worthless. He finally resold the property to the previous owners for $8,000. The 1880 census shows 253 Chinese residents, but many think the Chinese population was greater than that. The Chinatown site is located in the northwest section of town. Little information about the 35 native Paiutes is given on the 1880 census. Only one was listed with a name, Captain Bob. The sudden growth of Bodie impacted the hunter-gatherer lifestyle of the native population. Some of the native people adapted by working in Bodie and other towns and ranches. Their small huts were found on the ridge above the town. They also worked at Hank Blanchard's lime kiln in Mono Basin. Many Paiute women worked as household help. Across the intersection to the southwest is the site of the Sawdust Corner Saloon, where Bodie's most disastrous fire began in 1932. A small boy playing with matches caused the fire. Wells Fargo's express office was also on the west side of Main Street. Shipments of bullion were protected by the company's armed messengers. The weight of 120-pound bullion bars also acted as a deterrent to stage robbers. Masonic Hall site, Chinese Laundry. On this site stood Bodie's Masonic Hall, Lodge number 252, established in 1878. Membership peaked at 93 in 1882. In 1918, the lodge consolidated with one in nearby Bishop. The laundry building currently on this site was moved from Bonanza Street. Town residents often moved buildings to different locations over the years, usually after fires. Bodie Bank site. All that remains of the Bodie Bank after the 1932 fire is its brick vault. James S. Kane bought the bank, founded by E.L. Benedict in 1890. Despite Bodie's Wild West reputation, its bank was never robbed. A nighttime burglary on September 1st, 1916, however, yielded $2,000 in cash, some bullion, and other valuables. Moyle Warehouse ruins. The Moyle Warehouse, built in 1879, was one of many stone warehouses constructed to store supplies for the long, cold Bodie winters. Kirkwood Stable and Blacksmith Shop. Hundreds of horses and mules pulled wagons that hauled tons of goods in Bodie's busiest years. This stable, owned by Stuart Kirkwood, housed a blacksmith shop where horses, mules, and oxen were shod. Jail. The town jail looked small in proportion to tales of lawlessness during Bodie's boom years. From 1878 to 1881, the jail was the responsibility of Constable John Kurgan. In an infamous 1881 incident, which resulted in Kurgan's temporary demotion, vigilantes took accused murderer Joseph de Roche from the jail and hung him. So we'll stop there. There is more. I've got a couple of pages left. So we'll stop there for today. Okay. Let's move on to jury charge. How are we doing on our time? Good. All right, now our subject with jury charge today is interpretation of state law. All right, so let me give you a word list. You're going to hear district court, authoritative, constitutionality, federal courts, adjudications, state courts, Raymond versus Clark, litigation, United States, district court, federal district court, Congress, constitutional. You're going to hear constitutionally, let's see, controversy. And then you're going to hear judicial fiat. Fiat is just an official order from a group or a person in authority. So you're going to hear congressional scheme. All right. I'm going to read this. I'm going to start at 120 and work my way to 160. Okay, here we go. I agree that the state action was properly enjoined, and so I concur in the opinion of the court to that extent, but I dissent from the direction to the district court to hold the case while the parties repair to the state court to get an interpretation of the Louisiana statute around which this litigation turns. That procedure is advisable where private parties question the constitutionality of a state statute. An authoritative construction of the state law may avoid the constitutional issue or put it in new perspective. Under Section 1331, the federal district court has jurisdiction where the matter in controversy exceeds the jurisdictional amount and arises under the Constitution, laws, or treaties of the United States. In litigation in the federal courts under that statute, the necessity of constructing state law arises because of the federal court's duty to avoid, if possible, a federal constitutional question. Here, although potential constitutional questions may lurk in the background, this litigation primarily concerns title to land claimed by the United States. It is litigation which Congress, by sections 1345 and 1346, has entrusted to the federal district court. Those sections allow civil litigation of the situation. It is the duty of the federal court to decide all issues in the case, those turning on state law as well as those turning on federal law. In Raymond versus Clark, a case in the federal courts by reason of diversity of citizenship, we refuse to remit the parties to the state court for decision of difficult state law questions. We held that it was the duty of the federal court to decide all issues in the case, state or federal, difficult or easy. There have been exceptions to this policy, notably in bankruptcy proceedings, where trustees are sometimes sent into state courts to obtain adjudications on local law questions pertinent to the administration of the bankrupt's estate. It is inappropriate to follow that course here. Congress has decided that the United States should have the benefit of the protection of its own courts in this type of litigation. We properly hold that the federal court, not the state court, has jurisdiction over the controversy, but we beat the devil around the bush when, having taken the litigation out of the state court, we send the parties back to the state court for its construction of Louisiana law, which is the most significant issue in the case. The problem is not only to construe the state statute, but to construe it constitutionally. The federal court can make that construction as readily as the state court. That is the congressional scheme, and we should not change it by judicial fiat. All right. Moving into Q&A. My first Q&A for you is going to be plaintiff questioning. Let me give you a word list. You're going to hear computer, insurance, highway, title, Hawaiian development, Honolulu, adjacent, coast, commercial, Patrick Carson, Donald Monroe, Lee, real estate, escrow, trust, Islands, Title Insurance, Trust Company, Hawaiian Development Corporation, Pearl Building, Coast Highway, all right. You're also going to hear equipment, and plaintiff is questioning, but the court and defense also jumps in a little bit, okay? All right, I'm going to start this at 120, and I will work my way to 140 with this one. Here we go. Mr. Lee, do you know the date of your first meeting with Mr. Monroe? I think you mentioned you thought it was somewhere in July. Yes, I assume that's when it was. It may have been earlier. Your best recollection is June or July of 2008? That's correct. I think you testified that in one of these conversations with Mr. Monroe, you received the impression that he wanted to sell the Pearl Building and 2 adjacent lots. Yes, that was the impression that I got, that he wanted to sell the land and the building as quickly as possible. I see. When was the first time you received this impression? When I went down there the first time. June or July of 2008? That's correct. Did Mr. Monroe ever state to you the land and the building were already sold? No, he did not. Were you ever told that the owner of the land and the building was the Title Insurance and Trust Company acting as the executor for the estate of Thomas J. Davis? No, I was not. Your understanding was that Daniel Monroe owned the building and the land? That's correct. No, Donald Monroe. I'm sorry, Donald Monroe. Mr. Lee, how were you first introduced to Mr. Monroe or referred to Mr. Monroe? Through a commercial real estate developer, Hawaiian Development Corporation. Excuse me, where are they located? They have several offices throughout the islands, but their main office is in Honolulu. Thank you. Do you remember the individual's name whom you spoke with at the Hawaiian Development Corporation? Yes, Patrick Carson. Did Mr. Carson refer you to Mr. Monroe? Yes, he did. Was Mr. Carson aware that Mr. Monroe was not the owner of the Pearl Building and the 2 adjacent lots? No, he was not. During your meetings with Mr. Monroe, did he ever refer to the Title Insurance and Title Trust Company as the owner of these properties? No, he did not. Did Mr. Monroe always refer to himself as the owner of the property? Yes, he did. Mr. Lee, I have here a document entitled Offer to Purchase for the property known as the Pearl Building located at 11820 Coast Highway, signed by you on July 18, 2008. Is that your signature? Yes, it is. I have here a canceled check dated July 18, 2008 for $450,000 signed by you. Is that your signature? Yes, it is. Mr. Lee, whom did you give this offer to purchase to? Ivan Monroe. No, Donald Monroe. Mr. Lee, whom did you make this check for $450,000 out to? Donald Monroe. Did Mr. Monroe accept your offer to purchase? Yes, he did. What were the terms of your agreement with him? The purchase price of the building was to be $1.5 million. Okay. The two adjacent lots were $140,000 each. Why did you give Mr. Monroe a check for $450,000 before the close of escrow? This was to purchase all of the office equipment, the printers, and the computers. At that time, were you aware that Mr. Monroe was not the legal owner of this equipment? No, I was not. Did you take possession of this equipment? No, I left it in the Pearl building. Okay, let's switch transcripts. This is going to be defense questioning. We're going to start at 120, and I'll work my way to 160. Do you recall the amount of the down payment that the parties made? I recall there was a gift letter in the file for over $120,000, or approximately $120,000. Now, is there a requirement that any down payment be a gift in order to qualify as a down payment for the purchase under the guidelines that you had to apply to this transaction at the time? It's a government requirement. It's a federal regulation that they cannot borrow funds for their down payment. And did you have any conversations with Mr. Netter regarding that $120,000 down payment? I was told that they were getting a gift for the funds, and I explained to them that there was a particular form that I would have to get to them, and they were to complete the form and mail it back to me. I was also waiting for pay stubs from Mr. Netter, and I received the gift letter and the pay stubs at the same time. Okay, and did Mr. Netter indicate to you that the money was in fact a gift? I assumed as much with the gift letter, yes. I don't remember a conversation in 2006 where we specifically sat on the phone and said, yes, it's a gift, or it's not a gift. I, as an underwriter, have to assume it is a gift. I have a form completed, and there is a caution notice at the bottom of that form that specifies that they are defrauding the government if it is not a loan. If it is a loan, and that document was completed and sent, yes, and it's in the file. And was it signed by the parties? Yes. And is it also signed? Are traditionally these letters signed by the individuals who make the gift? Yes, it's completed by the donor, and they are to specify the relationship to the person, and they have to be a close living relative or non-interested party in the transaction to be able to give the gift. And they have to specify at the bottom of the form their name, address, and phone number in case the lender wishes to contact them. It is not a requirement by the government or U.S. as the lender at that particular time to verify the donor's ability. In fact, they couldn't have purchased the home if this had not been a loan, could they? No. And do you have an idea where a copy of this gift letter might be at this time? It would be in the purchasing file when they purchased their home. The problem is they've sold the home since. The loan was insured by FHA, the Federal Housing Administration, excuse me, and I don't know if they keep copies of those. I don't work at FHA, So I don't know if they keep copies of those packages after the loan has been sold and closed and a zero balance has been maintained. Your Honor, if I may, at this time, I'd object and move to strike any evidence as to what was contained in the gift letter. The best evidence is the letter itself. Well, I'll allow cross-examination, and you can review the motion. Go ahead, Ms. Hendrickson. Now, you previously stated you received the gift letter with Mr. Netter's pay stubs. Is that correct? Correct. They were in the same envelope. You recall that? Correct. At any time, do you recall Mr. Netter ever making a statement to you that this was in fact a loan? No. I have no further questions of this witness. Mr. Anderson? Ms. Robertson, you don't have the gift letter, correct? Not on my person, no. How many of these things do you do a month? A month? I'm doing approximately 8 to 15 loans a day. So how is it you can remember back in 06? It's my sister's loan. It's your sister's loan? Correct. I was helping a family member. At whose request did you? Both parties. I received a call from both parties. They were at a real estate office and they wanted me to come down and help them with the transaction, and I did. Why is that? Because it's my sister. Because they were having trouble with the other one. Is that correct? With the other, they had already tried to get financing before. Isn't that correct? Before they called that, I wouldn't know that, no. They'd been with a realtor trying to get into this house. Is that correct? I don't recall that, no. Were they desperate to get into the house? No. Were they really wanting to get into the house? I wouldn't know that. I don't know their personal feeling. Just a minute. I'm doing fine. Just a minute. What's the question, Mr. Anderson? Were they anxious to get into a house at that time? Not any more anxious than any other buyer I'd do a loan for. But this was their first house. So are a lot of my loans. And this is your sister, and they got a kid on the way, correct? At that time, no, I don't believe so. I don't recall. 2006, I don't suppose you recall your sister saying, I don't care what you have to do, get us into this house. Objection, Your Honor. I believe that this constitutes testimony, and I don't think it's a proper question. It's not in the form of a question. Did your sister make that statement to you? Yes or no? No, not that I recall. Did she ask you to make all your best efforts to help them out? Not in, I don't recall those words, no. I probably did my best efforts, yes. You were working on the loan at the time, is that correct? I beg your pardon? You were working on a loan for your sister. Yes. Did you send the gift letter back to Pennsylvania where his parents were? No, I believe I sent it to Cindy and Steve personally to email it on. So you have no idea who signed it? It could have been Cindy. It could have been anyone. It could have been you. It probably wasn't. No further questions of this witness. Further redirect? Further questions, counsel? No, Your Honor. No, Your Honor. Thank you, ma'am. You may step down. Further evidence, Ms. Hendrickson? No, Your Honor. Mr. Anderson, anything? No, Your Honor. Again, we would move to strike any evidence regarding her testimony as to the gift letter and what was contained on there. All right, that request will be denied. Any argument on this point? Your Honor, if I may, I think the exhibits are clear. It says $120,000 on the check. It's a loan. It was signed by both parties. If there's any question as to statute of frauds or anything like that, I can present the court with authority that constitutes a valid written contract. The loan apparently was, by the testimony of the respondent, was in the handwriting of the petitioner's father. My client so testified to that. I don't think there's any doubt. If you look at those 4 letters and compare them to the rest of the letters on the check, it's clear that it was on there. Now, he died 4 months after that. Mr. Anderson, where are the exhibits? I think I have them back over here. Thank you. Proceed. I think it's clear it was written by the same person. Now, he died approximately 4 months later, if I recall the testimony. I don't see how there would be any reason whatsoever for something to have taken place between this time and that time, or between the time that he wrote that and the time that he died. I don't see why there would be any reason for him to go back, find the check, write loan on it, and stuff it away somewhere. If that becomes a critical issue, we've requested the opportunity to have that document examined for its authenticity. And also, again, if it's critical, to be able to get the records from the bank upon which it was drawn back at the time. The email would show what was on that check when it cleared the bank. The letter is to his sister, and clearly it explains what was going on, and it dovetails with the $11,030 and the $970 that were mentioned in there as the amount that the respondent has contended all along was paid on that debt, Your Honor. We don't have a gift letter, so I don't think the court can assume that it was signed by Constantine Netter and Sophie Netter. I don't know if it was signed at all. I don't know if there is one, but I don't think that it can be considered as any evidence of intent of this document here, the $120,000 check. I think all of it would be evidence for was that the parties were trying to get into this house. All right, so let's go ahead and do some read back. Okay. This is one page, and I'm going to read this once at 120, again at 140, the last time at 160. This will be plaintiff questioning. You're going to hear entities, corporations, and judgments. Here we go. Do you have judgments against any of these corporations? No. Do you have judgments against any individuals that were associated with these corporations in any way? No, not other than the 2 I have listed now. Now, have these 2 judgments been satisfied in whole or in part? Satisfactions of judgment in full have been filed. Both judgments? Both judgments. Now, as to the first action you mentioned, is that the satisfaction of judgment coming from the money that is in dispute in this action? It is my understanding. It is. Yes, sir. And then there was a partial satisfaction in the second action you have mentioned, also involving these same funds. Is that correct? That is my understanding, yes. Now, other than the monies that are involved in this action, how did you obtain satisfaction of judgment in this second action? How did you obtain the $100,000? I did not obtain any additional money. The debt owed to me had been satisfied, so I filed a satisfaction of judgment to clear the record. What person or entities satisfied the portion of the judgment that is not involved in this action. As I said, there was no additional money paid. There was no additional money paid to you. That is right. You never received any more than the $30,000. That is correct. All right, so let's do that again at 140. Do you have judgments against any of these corporations? No. Do you have judgments against any individuals that were associated with these corporations in any way? No, not other than the two I have listed now. Now, have these two judgments been satisfied in whole or in part? Satisfactions of judgment in full have been filed. Both judgments, both judgments. Now, as to the first action you mentioned, is that the satisfaction of judgment coming from the money that is in dispute in this action? It is my understanding. It is, yes, sir. And then there was a partial satisfaction in the second action you have mentioned, also involving these same funds. Is that correct? That is my understanding, yes. Now, other than the monies that are involved in this action, how did you obtain satisfaction of judgment in this second action? How did you obtain the $100,000? I did not obtain any additional money. The debt owed to me had been satisfied, so I filed a satisfaction of judgment to clear the record. What person or entities satisfied the portion of the judgment that is not involved in this action? As I said, there was no additional money paid. There was no additional money paid to you. That is right. You never received any more than the $30,000. That is right. All right, last time at 160. Do you have judgments against any of these corporations? No. Do you have judgments against any individuals that were associated with these corporations in any way? No, not other than the two I have listed now. Now, have these two judgments been satisfied in whole or in part? Satisfactions of judgment in full have been filed. Both judgments, both judgments. Now, as to the first action you mentioned, is that the satisfaction of judgment coming from the money that is in dispute in this action? It is my understanding. It is, yes, sir. And then there was a partial satisfaction in the second action you have mentioned, also involving these same funds. Is that correct? That is my understanding, yes. Now, other than the monies that are involved in this action, how did you obtain satisfaction of judgment in this second action? How did you obtain the $100,000? I did not obtain any additional money. The debt owed to me had been satisfied, so I filed a satisfaction of judgment to clear the record. What person or persons or entities satisfied the portion of the judgment that is not involved in this action? As I said, there was no additional money paid. There was no additional money paid to you. That is correct. You never received any more than the $30,000. That is correct. All right, so let's read that back. You're going to choose whether you want to read back the 120, 140, or 160 take. And I'm going to read this. Okay. All right, so question. Do you have judgments against any of these corporations? Answer, no. Question. Do you have judgments against any individuals that were associated with these corporations in any way? Answer, no. Not other than the two I have listed now. Question. Now, have these two judgments been satisfied in whole or in part? Answer. Satisfactions of judgment in full have been filed. Question. Both judgments? Answer. Both judgments. Question. Now, as the first action you mentioned, is that the satisfaction of judgment coming from the money that is in dispute in this action? Answer. It is my understanding. It is. Yes, sir. Question. And then there was a partial satisfaction in the second action you have mentioned, also involving the same funds. Is that correct? Answer. That is my understanding. Yes. Question. Now, other than the monies that are involved in this action, how did you obtain satisfaction of judgment in this second action? How did you obtain the $100,000? Answer. I did not obtain any additional money. The debt owed to me had been satisfied, so I filed a satisfaction of judgment to clear the record. Question. What person or entity satisfied the portion of the judgment that is not involved in this action? Answer. As I said, there was no additional money paid. Question. There was no additional money paid to you? Answer. That is right. Question. You never received any more than the $30,000? Answer. That is correct. Okay, so that concludes our mid-speeds live class. Have a wonderful day.